Welcome to This Explainer. Okay, today we are unpacking one of the absolutely fastest moving, most fascinating areas of consumer law in the world right now. We're diving deep into Indian e-commerce law. Specifically, we're following a really clear meta-narrative here, how what started out as soft theoretical guidelines has rapidly hardened into a very real aggressive enforcement ladder. And we're talking serious monetary penalties for something we have literally all experienced online, dark patterns. So if you've ever felt, kind of tricked by a website into buying something you definitely didn't want, you're going to want to pay close attention to how this legal landscape is shifting to fight back.
Okay, let's dive into the syllabus. We're going to cover Section 1, the Consumer Protection Act 2019, Section 2, the E-commerce Rules of 2020, Section 3, Regulating Dark Patterns, Section 4, Real-World Enforcement, and finally, Section 5, the 2027 Dual Regulation Era.
Section 1, the Consumer Protection Act 2019, the statutory foundation. So, the massive shift here is that the 2019 Act replaced the much older 1986 legislation, and for the very first time, it explicitly brought e-commerce transactions under the exact same umbrella of regulated consumer transactions. It doesn't matter if you're buying something offline in a brick-and-mortar store or scrolling through an electronic platform, the legal definitions of consumer and unfair trade practice now apply equally across the board. To actually enforce this, Section 10 of the Act established something entirely new, the Central Consumer Protection Authority, or the CCPA. Now, the absolutely crucial phrase you need to understand here is suo motu. What does that mean? Well, it means the CCPA doesn't have to sit around waiting for an individual consumer to file a complaint. Unlike the older, frankly much slower consumer dispute redressal commissions, the CCPA is a dedicated, highly empowered regulator. They can act entirely on their own initiative, they can proactively investigate unfair practices that affect consumers as a whole class, they can order recalls, and they can direct the immediate discontinuation of deceptive practices. This aggressive new authority completely changed the game.
Now, what's really interesting here is the sheer severity of the penalties laid out under Section 89 of the Act for false or misleading ads. This is not just a slap on the wrist. For a first offense, we are looking at imprisonment of up to 2 years and a fine of up to 10 lakh rupees. And if a platform dares to be a repeat offender, there's no way around it. That scales up to 5 years of imprisonment and a massive fine of up to 50 lakh rupees. This establishes incredibly high stakes right out of the gate. We're talking about a heavy statutory hammer hanging right over these e-commerce platforms.
Section 2, E-commerce Rules of 2020, defining liability. The 2020 rules create distinct legal obligations by splitting e-commerce into two fundamental structures. On one side, we have the inventory-based model. This is where the e-commerce entity directly owns the goods it sells. Just think of a conventional retailer operating online. Here, ordinary seller liability applies. But on the flip side, we have the marketplace-based model. This is essentially an IT platform that just connects buyers with third-party sellers. Now, this distinction is absolutely vital, because India's foreign investment rules generally bar foreign-backed e-commerce entities from holding their own inventory. So this effectively forces giants like Amazon and Flipkart into that marketplace model, which in turn triggers incredibly strict due diligence obligations for those platforms. They literally can't manipulate search results unfairly, they absolutely must display country of origin information, and crucially, they have very strict rules around consumer consent.
So the crucial point here, the tipping point really, is Rule 49. It explicitly prohibits pre-ticked checkboxes or any form of auto-recorded default opt-in consent. Why does this matter so much? Because this single sub-rule is the absolute statutory core for essentially the entire crackdown on dark patterns we are witnessing today. When you see a dark pattern violation in India right now, at its legal heart, it is almost always a Rule 49 violation dressed up as clever interface design.
Section 3, Regulating Dark Patterns, the current frontier. Look at this timeline because it brilliantly illustrates the massive regulatory momentum we're dealing with. We go from the broad Consumer Protection Act back in 2019, stepping up to the e-commerce rules in 2020, then under Section 18 of the Act, jump to November 30th, 2023, where the CCPA introduces the guidelines for prevention and regulation of dark patterns. This was huge. It gave dark patterns a formal legal definition in Indian law for the very first time. Basically, deceptive user interface design intentionally structured to steer users into decisions they wouldn't normally make. And that escalation continues right up to June 2025 with a formal self-audit advisory. Those 2023 guidelines explicitly identified 13 specific categories of dark patterns. We're talking about those everyday digital frustrations finally getting formal legal names. False urgency,
You know, that incredibly stressful, completely fake countdown timer hovering over your shopping cart. Basket sneaking, when an extra item just mysteriously appears at checkout. Confirm shaming, literally guilt-tripping you into signing up for a newsletter by forcing you to click a tiny button that says something like, "No thanks, I hate saving money." Then there's forced action, subscription traps, disguised advertisements, and drip pricing, where the final price ends up mysteriously way higher than the initial display. It is an exhaustive list, and it directly targets manipulative design.
Following a major stakeholder meeting, the CCPA escalated things even further by issuing a formal advisory in June 2025. This directed all e-commerce platforms to conduct self-audits within 3 months, eliminate their dark patterns, and submit voluntary self-declarations of compliance by December 2026. However, and this is a big however, to really understand this in depth, we have to acknowledge a legitimate advanced critique coming from digital rights groups. Their core criticism is that this 2025 advisory is, technically speaking, soft law. It doesn't carry an explicit penalty for noncompliance, and it relies entirely on the platforms to police themselves without any specified independent audit or verification mechanism. It's a really fascinating tension between strong regulatory intent and practical enforcement capability.
Section 4, Real-World Enforcement, from Theory to Penalties. We are definitely not just dealing with theory anymore. Let's look at specific, named entities that have actually faced the music. Vizixwala faced suo moto action for a pre-selected 10 rupee donation at checkout, which is a textbook case of basket sneaking, coupled with some emotionally manipulative messaging. They also advertised courses as free, but required users to surrender personal contact data first, which got categorized as a disguised advertisement and forced action. Then you have Book My Show, hit with a notice for automatically adding a 1 rupee charity donation via a pre-ticked box. They actually had to update their interface to require a genuine opt-in, and Indigo received a notice for opaque interface design, allegedly obscuring free seat options to nudge users toward paid upgrades. These everyday interface choices, they are now legally actionable. 7 million rupees. That is the highest individual penalty handed out by the CCPA for these types of violations, and it was levied against the platform Zepto. The penalty was specifically for hidden charges and automatic enrollment into paid memberships. To put that into perspective, this single number absolutely proves that the CCPA is no longer just sending polite warning letters. They are hitting companies where it actually hurts their bottom line. Now, if we zoom out to the macro data reported to Parliament in 2026, the true scale of this enforcement ladder becomes incredibly clear. Between December 2023 and March 2026, against a backdrop of 308 consumer complaints, the CCPA issued 42 notices for dark patterns and imposed 20 lakh rupees in total penalties across 9 different companies. And it's not just the ones we've already discussed. Other penalized entities include major names you definitely know, like FirstCry, PharmaEasy, McAfee, SpiceJet, and the online coaching entity Anuj Jindal. Honestly, very few areas of Indian law have moved this fast or generated this much real enforcement data this quickly. Section 5, the 2027 Dual Regulation Era. Let's move ahead and see how all of this builds towards the future, because the regulatory landscape is about to get significantly more complex for these platforms. By May 2027, the Digital Personal Data Protection Act, or the DPDP Act, and its rules are set to reach full operational force. At that exact point, dark pattern practices that touch personal data specifically, like deceptive consent flows, will sit squarely under dual regulation. On one side of the ring, you have the CCPA enforcing the dark patterns guidelines and e-commerce rules. On the other side, you have the Data Protection Board of India enforcing the explicit consent requirements under Section 6 of the DPDP Act. So what does this all mean? It leaves us with a massive regulatory headache on the horizon. When a single deceptive interface, say a really tricky checkout flow, triggers 2 structurally different statutes, how will platforms survive the crossfire of dual liability? Think about it. A single pre-ticked box could expose a platform to parallel proceedings from 2 entirely different regulators at the exact same time. The era of loose compliance is completely over, and the enforcement ladder, it has clearly only just begun to climb. Thank you so much for joining me for this in-depth explainer.